Good morning, ladies and gentlemen, and a warm welcome on behalf of EQS Group and our partners from KPMG Law. So welcome to our webcast. Today, EU Directive Part 3, Transposition Status of the EU Directive is going to be the topic for today's session again. So some of you might have been participating in one of the past sessions about this topic, so you will be familiar with the format. For the others, we'll introduce quickly how this works and what we're going to do in the next approximately 90 minutes. So there is a number of experts from KPMG and KPMG Law who will be updating you on the transposition status in the different EU countries. We'll hand over to the colleagues then later on, and they will introduce themselves. So welcome to the KPMG team here on the webinar. Really a pleasure again to have you here. And I'm really looking forward to have a great session. Just one technical remark. It might be due to technical reasons that not each and every speaker can switch on the video when presenting, but at least you will hear all of them. So we'll see. It's one of these technical challenges that we all learned to live with over the past years now. Then a quick update function-wise maybe. So in this webinar platform, you have control about certain features. So you can enlarge parts by clicking on these arrow buttons that you see here. If you find the bubble with the question mark in it, this is where you can ask questions, and we will see the questions and collect them and then take them up for the FAQ session at the end, or if it's a good fit, also take them up in between. So I will take care of this on your behalf. And there's also this black icon with a question mark. If you're having any technical issues, please feel free to click on it and file your question. And yeah, material for download is available as well for you. So by saying this, let's move and jump right into the topic. It's gonna really a pleasure to see how these things develop, where we somewhen a year ago all probably expected that around about 17th of December 2021 the EU directive would come into force and all the countries would have transposed into national law. I think we've all learned that there were some slight delays maybe involved here and there. Some countries were ready and ready even earlier than mid-December last year. Many countries are still not yet where they are supposed to be, but we'll see this in a second. The good news is that many of you, so companies, organizations that will be affected, are affected of the directive, have already started to take care. Some of you since many years already, some just recently maybe initiated or triggered through the upcoming directive. And I would like to open a poll question at the beginning. So you should now be able to see it. And we would really appreciate if you participate and just give your answer. So the question is, what is the status of the implementation of the Whistleblower Directive in your company/organization? This is something, so if you provide your answers, that is quite helpful to see who we have in the audience and where you are actually. So let's give you a few moments of time, let's say half a minute, maybe a little bit longer. Okay, so let's take a look. So it jumped over to the results. So 80% actually saying they already have a whistleblower system in place for some time that meets the requirements of the directive. This is really a large a large share of the answers, I must say. So I think in the last sessions a few months ago, we've rather seen kind of maybe 30% result here, but still 10% having a whistleblower system in place that probably does not meet the requirements, and another 10% are saying we do not have anything in place or have not yet started to implement something because we just first wait for the transposition. And that's a good keyword to hand it over and move over to KPMG. So again, happy welcome to Bernd Federmann and his team. Bernd, over to you. A pleasure to have you here. And yeah, curious to see where we are.
Yeah, many thanks, Jens, and welcome to the audience also from KPMG. My name is Bernd Federmann, partner with KPMG Law in Germany, and focus on compliance advice. Today, the colleagues of KPMG Integrity Service Network want to give you again an overview over the current status of transposition of the directive into national law throughout the 27 member states. The KPMG Integrity Service is a global network of more than 70 independent KPMG country offices specialized on legal and on forensic advice on all topics around whistleblowing, which we do together with our alliance partner EQS Group. So we can go to the next slide. Thank you. Here, the EU directive on the protection of whistleblowers requires all organizations with more than 50 employees, as well as the public sector, to set up internal reporting channels and a case management system to report and process violations, especially of European law. Here you can see the agenda we have prepared for you today for today's webcast. The EU Whistleblowing Directive is expected to be largely implemented in the European member states in the course of 2022. Johanna Trautner and Nadine Kern will give a high-level overview over the situation in all member states, where the directive is already transposed, where exists a draft law, and where nothing has happened so far. Then we will have some deep dives into the situation of Austria, that is done by Susanne Flöckner, to Finland, that is done by Antti Aalto, and in Sweden, that is done by Felicia Johansson. At the end, EQS will present the system, which is technically able to cover all these legal requirements, done again by Jens Gessler. The colleagues will each shortly present themselves when starting their own contributions. The presentation will, after the webcast, be sent upon request to you. So I think we can go to the next slide, please. The status of transposition of the EU Whistleblowing Directive varies across all the EU member states. The status is of September 22, shown here on the map. As you can see, 10 member states have already transposed the directive into national law. 14 member states have their transposition laws on the way. And there are only 3 countries left which have even not a draft law. The members of the Global KPMG Integrity Service Network have prepared a white paper with an overview of the current transposition status in each member state and advice on the local specifics. We will have an edition in September 22, which will be published probably in the next 2 weeks. And also EQS has prepared a respective white paper, and KPMG was also happy to largely contribute to this. The details of the member state situation are now in the following outlined by my colleagues, and I am happy at this stage to hand over to Johanna and Nadine. Thank you.
Thank you, Bernd. My name is Nadine Kern from KPMG Law in Germany. I'm an employment law expert, and I'm currently involved in many projects to implement whistleblower systems in companies and groups. In the next few minutes, my colleague Johanna Trautner and I will give you, as Mr. Federmann has already mentioned, a brief overview of the implementation status of the EU countries, which our colleagues will not go into detail at a later stage. We will start with few countries that have already implemented the directive. Next slide, please. The first one is Cyprus. In Cyprus, the directive was transposed into national law in February this year. In addition to the reporting topics of the directive, further reporting topics such as criminal offences, including corruption, non-compliance with any legal obligation, violations imposing danger to security or health of a person have been added. Anonymous reporting of violations and reporting by email are permitted. And for small companies, the law does not have to be implemented until December next year. And the penalty for violations is up to 30,000 euros.
Thank you, Nadine.
I will hand it over to my colleague, Johanna.
Good morning, everyone. My name is Johanna Trautner. I'm a lawyer at KPMG Law in Germany in Stuttgart and senior associate in the team of Bernd Federmann. And I'm happy to introduce you first to Croatia. Croatia has transposed the directive to national law in April this year. After 2 readings in late 2022, the Croatian Parliament adopted the Croatian Whistleblower Protection Act, which transposed the EU Whistleblowing Directive. It contains violation of national law and criminal offences as additional reporting topics. The anonymous reporting is permitted. Also, the reporting via email is permitted. Companies with less than 2,050 employees can share internal reporting channels. The whistleblower protection against retaliation is stipulated. There is a fine for violations stated, converted 4,050 euro for legal entities. There is no separate regulation on data protection, and the employee participation by a trustworthy person of works council or trade union is provided. There is no obligation to notify an authority for the implementation of a whistleblowing system. Next slide, please.
Next one is Denmark. Denmark has already transposed the directive and the national law is in force since June this year. For small businesses, a later implementation date applies. This is December 2023. Also, the Act allows a group to set up a shared whistleblower system which covers all member companies within the group. At the same time, the employer can fully or partly outsource the whistleblower unit tasks and whistleblower tool to an independent third party, such as lawyers or auditors. Email reporting is not prohibited as a reporting channel and are processed the same way as reports made through other channels.
Let's have a look at France. France has also transposed the directive to national law in February this year. On March 21, 2022, the law transposing the UI directive was enacted in France. Finally, the entities subject to the French law had time until the 1st of September this year to comply with its provisions. The reform now came into force on the 1st of September. It covers all entities, public or private, with more than 50 employees. As such, no transitional transposition period for smaller companies with 50 to 2,049 employees was provided. It is stipulated that the whistleblower may either use the internal whistleblowing system or the competent external authority. There is a whistleblower protection against retaliation. The civil fine for delaying or abusing practices is 60,000 euro. Persons who discriminate against a whistleblower may be sentenced to a 3-year prison term and a 45,000 euro fine. As provided by the EU directive, companies with less than 2,050 employees could combine their procedure for collecting and processing reports. Finally, the French law does not include fines for companies that did not implement or did not implement sufficiently the legal requirements regarding the whistleblower system. However, the fact that the whistleblower may choose either to submit its report externally or internally may increase the number of external reports and lead to reputational risks for companies. Next slide, please.
In Ireland has now also transposed the directive into national law in July this year. This Transposition Act is a significant expansion of the Irish Protected Disclosure Act 2014. For small businesses, the law will only take effect from December 17th next year. Violation of purely national law do not fall within the scope of the Act. In addition, the personal scope of the law has been expanded and now also covers, for example, volunteers, board members, and shareholders. The Act does not contain provisions on the treatment of company group matters. Internal reporting channels and the disclosure process may be handled internally or by an external third party authorized by the employer. But companies under 250 employees can share internal reporting systems. There is no specific allowance in relation to anonymous reporting. The penalty of violation is up to 250,000 euros. For natural persons, also imprisonment of up to 2 years is possible.
Let's have a look at Latvia. The EU Whistleblowing Directive transposed to national law in February this year. The transposition law follows the directive largely. It contains violation of national law and criminal offenses as additional reporting topics. The anonymous reporting is not prohibited, but anonymous reporting persons are not protected and no investigation needs to be initiated. The reporting via email is permitted. Companies with less than 50 employees can share internal reporting channels. The whistleblower system can be outsourced to third parties, including law firms. There is the whistleblower protection against retaliation. There is no separate regulation on data protection, and the employee participation via employee representatives is provided. There is no obligation to notify an authority for the implementation of a whistleblowing system. Next slide, please. Like neighboring Latvia, Lithuania transposed the directive to national law and is enforced since February this year as well. The transposition law largely followed the directive. Any violation of law in public interest as additional reporting topics are stipulated. Private legal entities with less than 50 employees must implement internal reporting channels if the activities relate, for example, to consumer and investor protection, financial services and capital markets, banking, credit, investment funds, payment services, prevention of money laundering and terrorist financing. Anonymous reporting is permitted, although the reporting via email is permitted. Companies with less than 2,050 employees can share internal reporting channels. The whistleblower system can be outsourced to third parties, including law firms. Whistleblower protection against retaliation is stated, and there is no separate regulation on data protection, and there's no separate regulation on employee participation.
Let's have a look to Portugal. In Portugal, the law was transposed in December last year. However, it did only enter into force on June 18 this year. In addition to the reporting topics of the directive, violent and civilly violent criminality, organized crime, and economic and financial crime are additional reporting topics. Fines for violation may reach up to 250,000 euros. Next slide, please.
In Malta, the directive was transposed to national law in December 2021, but whistleblower protection legislation has been already in place in Malta since 2013. It includes the violation of national law, including criminal offenses, as additional reporting topics. Anonymous reporting is not prohibited, but anonymous reporting persons are not protected. The email reporting is allowed, Companies with less than 2,050 employees can share internal reporting channels. The Whistleblower Protection against Retaliation is stated, reporting employees are entitled to support by facilitators. There is no separate regulation on data protection, and there is no obligation to notify an authority for the implementation of a whistleblowing system. Our colleague will report on Sweden in detail later, so we can go to the next slide.
And now we came to the member states where there is already a draft, but it has not yet been implemented or is in force. The first member state we have a look at is Austria. And our colleague Susanne Flöckner will report on this in detail later. So the next member state I present is Belgium. In Belgium, the directive is not transposed, but a draft was prepared in July 2021. The draft bill should be introduced in Parliament by any time. Intention is to have a legal effect on the 1st January next year, whereby small business have a later implementation date, December 2023. The draft bill largely follows the directive. Additional reporting topics are tax fraud and social fraud. Companies under 250 employees can share internal reporting channels, and there are no regulations on centralized group reporting yet. A fine up to 5% of the annual turnover is possible in the case of violation, and a prison term up to 3 years and a fine up to 6,000 in case of natural persons.
Let's have a look at Bulgaria. While Sofia failed to implement the EU Whistleblowing Directive ahead of the deadline, a new law transposing it entered Parliament in April 2022. The draft contains additional reporting topics as crimes of a general nature of which the whistleblower has become aware in connection with his or her work. Companies between 50 and 2,049 employees may use a common internal reporting channel by identifying one person or a separate unit to receive and register reports for breaches. Whistleblower protection against retaliation is required. The anonymous reporting is not prohibited. There is no separate regulation on data protection. The employee participation occurs via employee representatives and trade unions. The fine for violation amounts up to €10,200.
In the Czech Republic, the directive is not transposed. There is currently a new draft bill available in the legislative progress. According to the current wording of the draft, it is supposed to be effective as July 2023. Information on possible unlawful act which has characterized of a criminal offense or violation Czech law regulation are possible additional reporting topics. Also, an internal reporting system can be shared by entities which employed an average up to 249 employees in the preceding calendar year quarter. Finally, anonymous reports are not prohibited, and the fines range from approx €800 up to approx €41,000, or 5% of the obligated entities' net turnover of preceding accounting period. Next slide, please.
The EU Whistleblowing Directive is not yet transposed in Estonia. The first draft passed Parliament's first vote in January 2022. It had received heavy criticism and hundreds of amendments, and its planned entry force on 1st June 2022 did not occur. The transposition is not expected to be finalized before the end of 2022. Small business have a later implementation date. It will be the 17th December 2023. The draft bill largely follows the EU Whistleblowing Directive. The draft contained the violation of national law, if not subject to sectoral restrictions, as well as criminal offences and different offences as additional reporting topics are contained. There are no reports on violations regarding employment relationship and state secrets. Anonymous reporting and email reporting are permitted. Group companies can share internal reporting channels. Further, the whistleblower system can be outsourced to third parties, including law firms. There's also whistleblower protection against retaliation. The fine for violation is up to 400,000 euro for legal persons and up to 1,200 euro for national persons. There's no separate regulation on data protection. There are no employee participation rights provided, and there's no obligation to notify an authority for the implementation of a whistleblowing system provided.
So now let's have a look on Finland, but our colleague Untitled will report on this in detail later, so we can move on to the next slide and present Germany.
Yes, I take over for Germany a little bit. The EU Whistleblowing Directive has not been yet transposed in Germany, as in the other states. Since April, a draft law of the Federal Ministry of Justice is in the regular legislative process. Since July, the governmental draft is available, and it is expected that the new German law will come into force in winter this year. This means in the fourth quarter, that means the upcoming months. At the moment, the parliamentary process is ongoing. Last Friday, the second chamber in Germany, the so-called Bundesrat, had a hearing. The Bundesrat has not raised any objections to the bill. Only partial proposals for adjustments were made, in particular with regard to regulation concerning state-owned entities and with regard to some data privacy aspects in particular. The statement is available on the internet site of the Bundesrat website. The agenda for the coming session of the Bundestag, that means we have now session weeks in the Bundestag, and this week today. This week is a session week, but also next week is a session week. The agenda for the next week has not been published. We await that the topic whistleblowing will be on the agenda for next week. And this in view of the positive opinion of the Bundesrat in this respect. So, to the details, I will, we have next Friday, that means on 30th of September, a detailed webcast together with our colleagues of EQS, which handles the situation in Germany in detail. So you are all invited to join next Friday, 30th September, and hear what's about in Germany. In principle, one topic for all the perhaps the colleagues from abroad. It was a long time discussion if we have a centralized or decentralized approach, and the German law provides for a possibility of a largely centralized approach. That means in group entities to have a centralized system available, and to be especially remarked that the fines can be very high in Germany. It may go up to 1 million euro in certain topics if you do not comply with the new law. That is shortly said about Germany. And in detail, again, you are invited for 30th of September next Friday. And then I'm glad to hand over to my colleagues again.
Yeah,
Thank you, Bernd.
Let me shortly interrupt, please, because we are getting a few questions if the slides will be available afterwards. So as Bernd Federmann said earlier, you can get the slides after the webinar. Just let us know if you're interested, and we will provide them to you.
And we will send it to you. Absolutely. That's no problem. You just write a mail, and then we will send you the slides respectively. Thank you.
All right, so let's move on. In Luxembourg, the directive is not yet transposed. The draft bill was published on 12th January 2022. It largely followed the directive. Anonymous reporting is permitted, and also the email reporting is permitted. Small business have later implementation date in December 2022. 2023, and whistleblower protection against retaliation is provided. There are no separate regulations on data protection, and the employee participation via employee representatives is provided. Next slide, please.
Let's have a look to Poland. In Poland, the directive is not transposed, but since July this year, a new version of the draft law exists. Now the draft is in the consultation progress. The date of the implementation is not predictable, but companies would have a maximum of 4 months from the date of publication to implement the law. For smaller companies, implementation is foreseen later by December 2023. Private legal entities might amend additional reporting topics to other violations of national law and/or internal regulations and ethical standards. In principle, the Polish draft law does not provide for the possibility of anonymous internal or external reporting. Also, legal entities and public authorities can decide to consider anonymous reports. External reporting channels are foreseen. The draft does not contain previous on the treatment of company group matters. Penalties for violations are according to the Polish Criminal Code. Now go to Romania.
In Romania, there are key steps for implementing the legislation into national law since July this year. Recently, the President has requested for the law to be reanalyzed and amended by the Parliament. Thus, we may see some adjustments made to the final version of the law. Currently, the law is pending in the re-examination phase in the Parliament. It is expected not to be delayed very long. The adopted draft law follows the provisions of the directive in principle. Violation of national law as additional reporting topics are contained. The Romanian draft law indirectly prohibits anonymous reporting, as such reports are to be dismissed for not meeting the minimum information to be provided by the law. Nevertheless, even if the report is submitted anonymously, the laws and its protection measures will apply to the persons that submitted the reports. The draft stated the whistleblower protection against retaliation. There is a fine for violation up to Euro 6,000 provided. The employee participation via employee representatives is stated, and there is no separate regulation on data protection. And finally, there's no obligation to notify an authority for the implementation. Next slide, please.
In Slovakia, the draft law has not yet been transposed. The bill was presented to Parliament in May 2022. The transposition is planned for the 1st November this year. The draft is an amendment to an already existing law. In addition to the reporting topics of the directive, violations of national law will also be possible as an additional reporting topic. An anonymous reporting should not be prohibited. The draft does not contain provisions on the treatment of company group matters, and violations can fine up to 200,000 euros. So let's have a look at Slovenia.
In Slovenia, the directive is not yet transposed. The draft bill was published in December 2021. Small business have a later implementation date in December 2023. The draft bill largely follows the directive. Anonymous reporting and the reporting via email are not prohibited. There's a whistleblower protection against retaliation, and the fine for violation amounts up to Euro 6,000. There are no separate regulations on data protection, and there is finally no special regulations for employee participation rights. Next slide, please.
Let's have a look to Spain. Spain has not yet transposed the directive, but there is an official draft law and amendment, a memorandum. In March 2022, the Council of Ministers approved the temporary draft law. The law, if transposed, would come into force 20 days after its publication. Small companies could have a late implementation date. In addition to the reporting topics of the directive, several violations of national law are possible as an additional reporting topic. The personal scope of the draft has been expanded and now also covers, for example, volunteers, board members, and shareholders. Also, there is a possibility of anonymous reporting provided. Group companies can share internal reporting channels, or the whistleblower system can be outsourced to third parties. Violations can be fined up to €1 million in very serious infractions. So now we have a closer look to the Netherlands. In the Netherlands, the directive is not yet transposed, but the draft bill was published last year in June. Current law already requiring small businesses to establish a procedure for internal reporting of suspected misconduct. At this moment, the new prospective measures already apply to the government employers. The transposition relates only to the EU directive, and the Dutch draft law does not include other violations of national law. This is also true for the law currently in place in respect of the whistleblowers. Anonymous reporting is not prohibited, and email reporting also. Small businesses should have a later implementation date. It's expected the 17th of December 2023. So next slide, please.
Now we'll have an overview about the countries where is no draft law. Let's look at Hungary. The directive is not yet transposed. There's no draft bill published yet. In Hungary, there is a current law applicable, which includes provisions on whistleblowing procedures mandatory for public bodies and local government bodies. Under the current law, anonymous reporting is not required. The email reporting is permitted. It could be expected that the draft law will also be applicable to state legal entities, departments, and other public corporations.
So let's have a closer look to Greece. In Greece, the first drafts were expected at the end of the first and during the second quarter of this year. Expectation is that public consultation on the draft legislation will take place in the coming weeks and months. Directive, not seen as a directly applicable to state legal entities, departments, and other public corporations after the transposition deadline. However, as per the case law of the EU Court of Justice, direct vertical effect of directives to protect the rights of the individuals. So let's have a look to the last state, Italy.
The directive is not yet transposed. No draft bill is published yet. Recently, in August 2022, the Chamber of Deputies gave final approval to a delegation law to delegate powers to the government for the transposition of European directives, including the EU directive of whistleblowing. Currently in Italy, there are 5 laws applicable, which include provisions on whistleblowing procedures. The directive is currently not seen as directly applicable to state legal entities, departments, and other public corporations after expiration of transposition period. And under current applicable law, the email reporting is permitted. There is no obligation to notify an authority for the implementation of a whistleblowing system. Next slide, please.
Hello, and a warm welcome from my side. My name is Susanne Flöckner from KPMG Austria. I'm partner for compliance and forensic, and I give you a deep dive into the actual status of the EU whistleblowing directive in Austria. So we were also not on time. The official draft bill for the so-called, should be called the Hinweisgeberinnen-Schutzgesetz, has been published in June 2022. There was a review period which ended in July 2022. There were a lot of comments on this draft bill, and it said that the law will enter into force one day after its publication. So we expect fall 2022, maybe it will be winter. And so the draft bill, it appears that it's largely will follow the regulations of the EU directive, but there are some exceptions. And with the comments, as I mentioned before, there was also a large comment from Transparency International on the draft bill, and I highlighted most of them in the next topics, in the next points. So the companies with more than 250 employees, they have a transition period of 6 months, which means that we do not expect that it will come into place before spring 2023. We have 9 different local states in Austria, so we have also 9 state laws. They will be slightly different to the nationwide law, but will be applicable for the legal entities under public law. Which is special for Austria maybe, it also includes corruption, but no further offenses, which is also a critical point from Transparency International. For example, cybercrime, sexual harassment, mobbing, and so on are not currently included in the draft bill. Furthermore, legal entities of every size are allowed to share internal reporting channels. The directive said not more than 250 employees. So it can also be outsourced to an external third-party provider, but there is no limit to the size of the company. Furthermore, the draft does not specify that the system, so the whistleblowing system in place, must be able to process anonymous messages. It says that you should accept anonymous messages, but it's not that they encourage that anonymous messages should be made. This is also a very critical point from Transparency International. Another thing is that internal reporting is preferable to the external reporting, and the external office shall be handled by the Federal Bureau of Anti-Corruption. But a little bit, we were a little surprised that it stated that this Federal Bureau of Anti-Corruption is required to evaluate whether an internal reporting would have been preferable, which means that they could ask the whistleblower why he didn't report via the internal whistleblowing system. So this is also a point that's very criticized by Transparency International, of course. Furthermore, it's not stated whether a group-wide whistleblowing system is acceptable or not, so this is still open. And another point for critics is that there are no sanctions for companies that do not implement the whistleblower systems in the draft bill so far. The draft bill foresees a 30 years retention period. This maybe contradict the limitation principles of the GDPR. We expect that there should be an amendment on that, but we will see. And the last point is that the bill does not specify any regulation on participation for the rights of employees with representative bodies. So far, it's not sure if you need if you have to get the agreement of the employee representative bodies or not in Austria. So these are the specifics in Austria, and I'm happy to hand over to Finland.
Thank you. This is Antti from KPMG Finland. What a lovely day we have here up north. As regards the Finnish situation, I'm glad to report that the Parliament actually received the draft whistleblower protection law on Tuesday, so 19th of September, which was anticipated, and we had a look at that. What the slide actually states is fairly accurate as regards the final draft that's now in the Parliament, so we can proceed with speed. As we are slightly behind the schedule. What we see or foresee is that the law is intended to be enacted as soon as possible, i.e. could mean during the fourth quarter. Finland does not have a preceding whistleblower protection law, say for the market abuse regulation required channel implementation need as per market abuse regulation. But as to where we are with regard to the requirements stated in the directive, the law proposal as such is 286 pages long. So it is reasonably detailed as compared to some other states within the European Union. The requirements are on some aspects quite detailed, but to my understanding, mainly in line with the requirements less specifically stated in the directive, but might come as a bit of a surprise. So it's I would describe the law as a law for engineers, a set of rules rather than general principles. The protection level has been actually hiked up since the first proposal draft of 21. So there is a second draft now in the parliament, and that reasonably complies with the requirements set forth in directive. The law or proposal actually contains a clause stating that the law per se does not limit the liabilities to the repatriate damages incurred by a whistleblower, which is a bit of a novelty since the first draft. There are some national legislation that might come into play, but let's not dwell on those. The acceptance of anonymous reports is within the law proposal, and the general approach of the Finnish legislation is that the internal channel should be prioritized before the national or European-wide public channels. However, that is of course with the requirement that the internal channel and the process complies with the requirements, and of course the most essential requirement is that the process and the system is credible and trustworthy, which is not an easy hurdle to make. The law is fairly silent on centralized systems, so it does not prohibit a centralized system being in place. However, the usage of a centralized system within a group of companies does necessitate putting into place some additional controls to deal with the problems that might otherwise appear. What the law actually puts forward in plain language is that the client management, which is by Finnish companies, limited liabilities companies, are liable to maintain and gather information on the operations. Hence, the whistleblowing channel and process put the management in the driver's seat, provided again that the system meets the criteria. One very specific clause in the draft law is that the employer entity is liable to make sure that the system and the process complies with the requirements, regardless of whether the process is provided internally or as provided by the law, bought from an external supplier. There are several national law requirements, especially based on GDPR, that need to be implemented whilst implementing the whistleblower channel, including data privacy impact assessment, works council process and acceptance, and the implementation of company internal rules and regulations on as to how the process is ran. And the independence requirements set forth in the law, or rather detailed in the law, probably favor the outsourcing of the process and the handling of the whistleblowers to an external reliable party. And currently there is a form of public whistleblowing channel at the Chancellor of the Justice's office that, however, maybe does not meet the requirements of the directive, but it is a traditional and long-established method of putting forward suspected wrongdoings in the Finnish society. With that, I thank you for Finland and pass the baton on. Bernd, please.
Thank you, Finland. Thank you, Antti. Then I think we can hand over to Sweden. Thank you.
Thank you. Thank you, Antti, for that view into Finland's law. My name is Felicia and I work for KPMG Sweden. I'm a risk consultant and I mainly work with forensic investigations. And I've also been part of the Swedish internal whistleblowing system that we have here at KPMG since early spring, meaning that I am part of developing and selling our internal system to clients, as well as assessing internal or reports that come in. And so the Swedish transposition happened in December 2021, meaning that nothing new has happened on the implementation side, really, since our last webinar on this subject. What is new is that some of the provisions of the law have entered into force, and this happened on July 17th, 2022. This meant that all public entities, as well as private entities with more than 250 employees, now have to have a whistleblowing system implemented. And this, of course, led to a huge rush in April, May, June, for all public entities and companies with more than 250 employees to make sure that they were in compliance with the law. And this is something we, of course, saw here at KPMG with lots of requests coming in to get our system. The next step will be for companies with 50 employees to 249 employees to implement the system. And this has to be done by December 17, 2023. And companies and public entities, they can have either internal reporting channels or external reporting channels. Some public entities are also required to have external reporting channels. And what really sets the Swedish law apart from the EU directive is that it has a much wider scope. So it's not just EU regulations that fall within the scope of the law. The law says that it is applicable to reports made in a work-related context of information about misconduct that there is a public interest in disclosing. And this is very broad, of course, and quite non-specific. And as I said, it does not only protect against breaches against EU law and not only against breaches against Swedish laws. What we're seeing is that also breaches against internal regulations and policies do in some cases actually fall within the protection of the law for those who whistleblow. But we are still waiting for precedents. There is no case law yet, meaning that the scope, the actual scope, is still quite unclear. But either way, it has to be, the whistleblower has to be intend or report about a misconduct that is of interest to the public. So it's not only private issues, those are HR questions, of course, still. But this wide scope of the EU or the Swedish implementation of the law is really what sets the Swedish law apart. I can also mention that, as has been mentioned earlier by my colleagues here, is that it is possible to share in reporting channels to some degree. So corporate groups can share reporting channels if they are above 50 employees or below 249 employees at the start of the year. Municipalities can also share internal reporting channels with their municipality-owned entities. And reporting can also can happen orally, written, or in person. And the most common way to report, what we have seen at least so far, is in writing, either through email or through a specific reporting channel. And I think I'll stop there and leave over to Jens.
Yeah, thank you very much, Felicia, and thanks to all the speakers, all the experts from KPMG. At this point, we'll probably see some of you again in the FAQ session later on. By the way, so all the questions that have been provided from the audience are written down, so we will take them up later on in the FAQ. Thanks already now for the good questions. It's going to be an interesting session, I can definitely promise. Maybe one short update regarding the transposition status in the different countries regarding Spain. The latest information that we have from our colleagues out of our Madrid office is actually that in Spain, it looks like that there is a delay which will lead to probably Q2 23. For the national law to come into force only. So this might still take more than half a year. That's the current expectation. From my perspective, interesting to see that beside France, who have transposed, but even they were late, all the big four are late, delayed, or like in the case of Italy, not even have a draft law that could be really properly reviewed. And so we'll see where this goes to. But I personally think end of next year, we should be in a situation where more or less all countries have finally transposed. And we'll probably do a celebration webinar on this then. We can discuss this later. All right, having said this, thanks again to the speakers from KPMG. I will just give you a very short intro solution-wise. So from our side, from EQS side, for those of you who are not fully familiar with us, EQS Group is the by far leading provider of whistleblowing solutions in Europe. So we're originally, the company was founded in the year 2000 in Munich, providing advanced solutions for investor relations. And a few years ago, it was decided to also look into regulatory market segments, which included compliance in the broadest sense and also whistleblowing. And today we are serving more than 2,500 whistleblowing customers worldwide, and by this being the market leader, especially for the European market. And so we've been dealing with whistleblowing and the EU directive from the very beginnings, and I think we've been working on the technical solutions that we provide since many years, always with the idea to make sure that any of our customers who would be in the need to implement a whistleblowing system or would intrinsically be motivated to do so, would have a solution where they can rely on fulfilling regulatory requirements and at the same time having a solution that includes and incorporates best practice experience from 20 years of whistleblowing, because this is not a new topic. It's always important to mention this. Whistleblowing is really not a new topic. It's been a fundamental part of any robust compliance management system since many years. And so many of you, and we've seen it in the poll earlier in this webinar as well, many of you have already implemented according systems because you are aware of where the benefits are, right? It's about you knowing first what's going on, you understanding what's going wrong in your organization, and this is why you would do it. And some of them, or some of the organizations and companies who have not implemented a solution for that, a whistleblowing scheme within the organization in the past, are probably now triggered by the directive, but it's anyhow a good thing and the right thing to implement whistleblowing in your organization. So what is said about EQS Integrity Line, that's the solution that we are providing for some of the larger corporates that might be the audience and might be existing customers for the Business Keeper solution, so the BKMS system. This is still a second solution that we're providing, so we're running both EQS Integrity Line, being a highly flexible whistleblowing solution that's now incorporated into the compliance cockpit, providing additional applications in one technical platform. And on the other hand, the BKMS system, looking mainly at larger, more complex and public institutions, has been on the market for 20 years, and we are continuing to provide it and to develop it. So whatever solution out of EQS Group you might be using or you might be implementing, you can be sure you have the right one. And what you see here, this is what our customers say. So ease of use of the solutions is given. So this is not a technical project. It's not going to be an IT project. It's easy and straightforward to implement it and set it up and use it. And quality of support is also highly rated when we ask people about the service that we provide. So I think you can be sure to have the right technical partner at your side. And on the left-hand side, these are things that are oftentimes forgotten when these days people start to gather information about potential whistleblowing solutions. It's important that you have a GDPR-compliant whistleblowing solutions. You need to be on the safe side, and using EQS Group solutions, you are on the safe side, because we're not only saying that it should be compliant or that it is compliant, but we are certifying this, right? So we are making sure that independent auditors take a look and confirm and assess and confirm that this is really the case, and we are not just saying it. And it's the same regarding security. So it's a difference if you only use ISO 27001 certified data centers, or if all your processes, your internal ISMS, Information Security Management System, is also certified, which is the case at EQS Group, and these are strong differentiators. So what would you get if you implement a solution that we provide? Clearly a web-based whistleblowing system with the option to also add a phone intake channel, a message intake channel to it. Highly secure, usable for potential whistleblowers from more or less any device. You just need an internet connection. That's all you need. And then it works, and a powerful back end for the case managers in your organization is clearly also part of it, so that you can handle cases, or in combination, for example, if you cooperate with KPMG and they support you around managing cases as well, then the colleagues would probably work for you or cooperate with you in the back end of the solution. So there's different options how such a system can be set up and implemented to meet your needs. So this, I will leave this for further reading. So some of the requirements coming from the directive that are also reflected in the national law, and clearly, as I said before, yes, our solutions are fully compliant with this. And so let's take a quick look. How does it work? So when you are interested and say, this might be a good idea to implement a whistleblowing solution from EQS Group, how does it work? You will get in touch with us. We'll show you the product. We make sure that we have the right contract in place, and then we implement. And within just a few days, you will be fully set up and running and complying to the whistleblowing directive. All right. Having said this, let me see what I noted as well before we enter into the FAQ session. Oh yeah, because there were a number of questions coming in the chat in between, still asking how can we get the slides, which email address do we have to write to? So we will send a follow-up email to all participants of the webinar, and in this follow-up email we'll include the email address you can write to and say, please can you share the slides with us, and then we will send them to you. So, with saying this, let's get into FAQ and see what questions we got. And we have a webinar about the transposition status within the EU member states. But maybe we start with the first question that we received, which is about a non-EU state, which is Switzerland. And actually, there was a question coming up that there are new rumors that in Switzerland they will probably now finally also implement a whistleblowing act. And the question was if any of the experts are aware of or have heard probably something similar. I'm not entirely sure. Bernd, team from KPMG, if anyone has heard anything about Switzerland. If not, we'll keep our eyes open and update afterwards.
Yes, I think we will do. We have our colleagues in Switzerland and asked about recent developments. As far as I know, there is not draft law existing in Switzerland for the time being. Yeah. However, it is so that implications of the European situation will also be in Switzerland, as there are multi-group companies. If they are forced to implement systems in Germany or in France, they do not have a reason why not to implement such system also in their Swiss subsidiaries. So implications, yes. However, I do not know about current draft law in Switzerland with regard to whistleblowing.
Thank you, Bernd. I would confirm this from our knowledge. I'm not aware of any news, and I've been following the situation in Switzerland for the past few years intensively, because some of you might know that there have been a number of initiatives trying to have a law, to have a legislation on this. And I think 1.5 years ago, roughly, it looked like it finally came to an end. So after, I think, the 5th attempt over 8 years, this topic was somehow dead in Switzerland, and I have not heard anything yet, but we'll check again. And if we know, we'll share the information through our channels. Then there was a question coming in asking about incentives. Quite interesting. So the question was if in any of the national legislation, so where we already have a transposition, there is an incentive for whistleblowers included in the transposing law. From my perspective, this is not the case, but open to learn different. Bernd, any opinion on this? Any insight?
We know from the discussion in Spain, as far as I heard it, that this is discussed at the moment. And however, the Spanish law is not in place now. So, however, I heard it from Spain that such an incentive regulation is discussed. We asked the colleagues of Portugal if it is also discussed there, but that's not the case. And we have the Portuguese law in place without such an incentive regulation. It is also in the discussion about the behavior of people and the science about the situation. How is it if you are incentivized to give hints about violation? It's not. It's very dangerous to see. So we have, on the other hand side, are you forced to give such hints according to your labor law contract as employee of the company? It might be possible, and that is depends on in Germany, for example, how the company wants to solve it. However, it is possible to rule out that or to make an internal directive in the company to force people giving hints about violations in the company. That is possible. And if it is the case and there is a works council which is competent, then he has to be included in the elaboration of such a solution. That is possible, but incentive in the law contained in incentivation for giving hints, that's only I know about a discussion in Spain. However, perhaps other colleagues may add additional information if they have.
This is Antti from Finland. And
Please, Antti.
Yes, indeed. In Finland, the law, on the level of law, no incentives have, to my understanding, been discussed, but the commerce has initiated some discussions to that effect. As Bernd explained, the companies willing to be rather well perceived as responsible companies have initiated the discussion about whether or not they would internally incentivize the whistleblowing. So that is appearing as a phenomenon in Finland for those who are very, very specific about their reputation of responsibility.
Thank you, Antti, for this comment and addition as well. So, because we are really having a lot of questions, let's continue to go through them. I think there's a lot of interesting learnings for everyone in the audience. So, one other question we received was about the communication of external whistleblowing channels that have to be implemented in the member state, and the question was, if companies are obliged to communicate about these channels. Bernd?
Yes, that is the case. It is a provision in the directive itself that forces for internal channels that those who want to give a hint are informed about the existing of external channels. So yes, you have to give such a hint, and the question is, when do you have to give such a hint? That is what we see in practice, because it is of interest, of course, of the organizations to have the information about a violation in their area and not to go to external channels where then maybe the prosecution, criminal prosecution service informs the companies and organizations about their own topics. Yeah, so the best interest is to have the information in the company, in the organization first, and be able to handle about it. However, it is necessary that you give a hint, and how you design it, when do you give the hint, and where, at which position, for example, in the questionnaire do you have to give the hint. That is about that what we are discussing with our clients, so that the intention that mostly all information stays within the company first can be achieved. So answer, yes, you have to, and you have to think about how to.
Mm-hmm. Thank you very much. Let me do an addition to this, just from a service provider's perspective. So at what point and at what place exactly, so like Bernd just explained, you are communicating these external channels or external authorities people could report to. We as EQS Group are currently building up an overview on this that could be shared. It's going to be a web-based list that our customers can get access to and that you could link to. Because this is the other question that came up in this context. Oftentimes now we would like to inform, and we understand we have to inform, but who are these external channels that can be used, and is there an overview? And we've seen that there isn't one. So we are currently building this up and providing it to you.
Yeah, we can say it's much confusion. For the one hand side, the national laws are not transposed yet, and therefore there are no determined external channels. However, there are a few external channels in different jurisdictions already existing, for certain kind of compliance areas. So it's a little bit a confusing situation, and in my opinion, it is also the task of the states to provide this information for their external channels, because external channels are state channels, where you can officially give your hint that is an external channel. And in my opinion, that is the task of the each member state to provide such a list and to avoid confusion in this respect. And it is it applies also to internal channels of state-owned entities or the state itself. So it is also an obligation of the state part, which have to implement channels to give such hints. So also the state has to give this information, and you should in principle, be able to read it about in the channels provided by the state, for internal purpose. So, that is a moving target.
Yeah, absolutely. And as you mentioned the word confusing, I would absolutely subscribe to this, because we are seeing that in some of the member states, we are talking about maybe 3 different places you could go to, while in others, we are talking about large 2-digit numbers, so 80 to 90 different channels, and it's at least moving target, and it's absolutely confusing. So we are trying to help as good as we can by removing the confusion around this. Wonderful. Let's move on to the next question. That's a short one, probably. There was a question about Portugal and if anonymous reporting is allowed. Clear answer to this: yes. So this has been different until I think roughly 4 years ago, where anonymous reporting was strictly prohibited in Portugal. But then even before the national transposition of the EU directive, there was a change in Portuguese law that allowed anonymous reporting, and changed this in a way that it was said it should not be preferred, but it's allowed, which is a slight difference. So you should not say you should report anonymously, but it's not. It's no longer prohibited. So you can go for anonymous reporting in Portugal. Then we have a number of questions around 2 topics that are somewhat all-time classics around the EU directive already. So one is about what exactly is the obligation in most of the national legislations and the directive. So some do not fully understand what is recommended. Verbal/oral reporting, written reporting, both, or either one or the other. Can you clarify this again?
Yes, you have to look on the national laws. The directive itself provides for alternative channels. It does not say you have cumulative, have all the 3 channels in place, but you have the chance to have alternative channels. That is how it is contained in the EU directive. However, you have to look how this is transposed into the national laws. And perhaps we have the colleagues, for example, from Sweden here. You can perhaps talk about how is the situation in Sweden, as I remember, it's not so clear in Sweden.
Well, the Swedish law says that reporting must be possible both orally and written, and also in person if a whistleblower requests a personal meeting. Yes. And with orally, then, of course, it could be over the phone or in person as well.
but it's not an alternative. You have also, you must also be able to report in writing.
You must also be able to report in writing. Yeah.
Okay.
And there is no specification on what this means. It could be over email or through a system or snail mail, but that's not very common, I suppose.
But for the companies and organizations, it does mean that they do need to provide this set of different options to comply with the Swedish law, where the directive would say if you only enable written reporting, for example, you're compliant in regards to the directive. So one of these aspects around the national transpositions where we see that member states are going different ways. So again, we as EQS are putting together such information, trying to give easy overviews to our customers, but it's also still a moving target, especially because the majority of the member states have not yet transposed. But it's a good bridge actually to the other topic that I already started to talk about. So another number of questions is around groups and whistleblowing systems and channels in company groups. And how is this, Bernd? Yeah, so it's coming back again and again. If I have a central channel in place already, and the country I'm headquartered in allows central and group-wide reporting systems, am I fine, or do I need to look at the national law again?
That's what we observed, and therefore we had, I think, 2 months ago, an extra webcast only handling this question: how is it best organized in group companies? And yes, so many aspects. The directive and the position of the EU Commission versus the transposition in national laws on the one hand side, then the question about data privacy solutions in this respect, all these aspects are very difficult. What we can see, or what is clear, in last summer, the EU Commission held, since then the Commission has the position that it is not possible to have centralized systems when you have a group of companies with which has 250 employees per legal entity and more. So it is said, no, it is not possible to provide centralized whistleblowing services. So each of these subsidiaries has to have its own channel and case management. That is the position of the European Union, and that does not fit to the reality we are faced in the existing situation, and big companies in particular, which have many subsidiaries, cannot handle this in this way. So that is also the position of many national, the national views of the national governments, and so that was the discussion about the Danish draft law, where this was firstly discussed. And we have solutions like it is in Germany. You have to see the directive itself. You cannot read about is it allowed or is it not allowed. Yeah, that is a position of the European Commission after the directive came into force. So it's not contained in the law, in the European law. So the national parliaments are free to implement the directive or transpose the directive as they see it. However, of course, the Commission is in the position to question the national laws. So it is a little bit a danger that you see if you have a national law which allows a centralized solution very explicitly, the Commission might come and declare this kind of regulation as not valid. However, this would be a not the decision of the Commission, however, a decision of the European courts. So in Germany, we had a solution that in the main text of the law, there was not an explicit statement to this. However, in the reasons for the law, it was laid out that it is possible to have such group solutions. So that is the solution in Germany and in many other countries, like we have it in France. We talked about Portugal there, and in further other countries, it is not possible. They hold the situation like the European Commission. So what is to say? It is not clear or not the same in all European member states. You have to look from country to country how the solution is there. And so unfortunately, we have not a very, that's also with regard to the implementation, also in transposition, a moving target, and it is not everywhere the same. However, the main countries, Spain, I think, France, also Germany, they have the possibility for a centralized solution.
Thank you very much for this. So this remains, I think, let's say, at least complicated, and I think we'll see over time what court decisions we get on this, what the Commission tries to initiate, how the member states react. But at the time being, you just need to look at the national legislation wherever you have subsidiaries, and then follow the law that you have there. There was one question for clarification about company sizes. So when we talk about larger than 50 or larger than 250 employees, Bernd, correct me if I'm wrong, then this is always related to the single entity. So the single legal
exactly.
entity.
We have a legal entity perspective always, not a group perspective. If we speak about employees, it's always the legal entity what we look at. Yeah, all the numbers are always related to the legal entity.
Okay, wonderful. Thanks for this confirmation. And then maybe also with regards to the time, there's one interesting question that I would like to still address. That's about the participation rights of the Works Council. So the question was related to the draft for Germany and what you've presented in the overview. So are there participation rights for Works Councils when introducing a whistleblowing system? Yes or no? And is it information or is it decision participation?
Yeah, if you have a Works Council and then you have participation rights, the betriebliche Mitbestimmung in Germany, and that is laid down in section 87 of Betriebsverfassungsgesetz. And if you introduce, for example, a technical system like the EQS system, then you have number 6. And just because of the introduction of a technical system, you have this participation rights of the Works Council, for example, in Germany. So, and yes, this kind of participation rights when implementing the system can be outlined in different ways. Yeah, so there might be the possibility of a Betriebsvereinbarung, an agreement, but there are also other possibilities for the Works Council to validly take its participation rights. That depends on that. What is the discussion? Yeah. So yes, there are participation rights existing, and you should, at a very early stage, take the Works Council into discussion.
Maybe one addition to this point, because this is a topic that we, as a provider, also discuss oftentimes with customers, and where we also support our customers with presenting and explaining the solutions to Works Councils. We would definitely anyhow recommend that you talk to the Works Council about this, because when you want to reach acceptance, when you want the Works Council to support the implementation of a whistleblowing system, it makes a lot of sense to involve them in all this, explain it so that they understand that this is not a scary technology, or so, because these are the things that we often hear. But that it really helps to protect the employees and the company. So cooperating with the Works Council on this makes a lot of sense. All right, so we are at the end of today's webinar. Thank you very, very much again to Bernd, to the colleagues from KPMG for providing all this expertise. Thanks to the audience for the great questions and for participating. As I said before, we'll send a follow-up email with some information and contacts you can reach out to. And don't forget to register for the webinar next week that Bernd also mentioned, which will be looking especially at the German transposition. I think this is really interesting for many here. Happy to welcome you on one of the next webinars. Have a great day, and thanks for participating.